Hi, I'm Greg Dell, here with attorneys Alexander Palomara and Cesar Gavidia. And Mutual of Omaha, disability denials is something that we're starting to see more and more. To their credit, on their sales side, they're selling a lot more group disability policies, which is almost everything that we see from them, which means these claims are governed by ERISA. And with that, people who are watching this video and found us are concerned about a denial and want help with a denial. So I want to give people an understanding as to what this denial process is about, what they should expect, the common reasons we see for these denials, and what kinds of policy language we see from Mutual of Omaha. So Cesar, I'll go to you first in terms of when dealing with Mutual of Omaha and you get a denial letter, what do you commonly expect to see in that denial letter from them?
So I could tell you that from the moment I'm going to get that letter regarding Mutual of Omaha or United of Omaha, there's going to be probably a quite extensive medical review process that was done. And the foundational basis of their denial is going to be almost exclusively that. Okay, there might be some additional stuff because I know Mutual of Omaha loves to conduct surveillance. They'll conduct surveillance very often in their
a lot
claims.
of surveillance.
A lot of surveillance, and they'll use that surveillance as part of the medical review. So they'll actually have their medical reviewer review that surveillance and use that as part of their basis to suggest or say that that there's no foundational support, that you have functional limitations that would prevent you from working in your occupation or any occupation, okay? So it's this kind of combined effort from their private investigative side to their medical side to deny the claim.
And then also we know they have this change of definition in their policy. And talk about the definition of disability and how it does change with them and how we see so many denials when it's changed.
Well, typically under these policies, they have, like you said, a change in definition of disability, which typically kicks in at 24 months. So for the first 24 months, it's a little bit easier to qualify for benefits because the initial definition of disability has that you have to be unable to perform the duties of your own occupation or your regular occupation. And if your job is a heavy lifting job or whatever it is, you can easily prove I have a back condition. I can't lift 100 pounds anymore. You qualify for benefits. But it gets a little bit more difficult to qualify at the 24-month mark because now the definition of disability changes. In order to qualify for continued benefits, you have to prove they're unable to perform the duties of any gainful occupation. Opens up the doors for Mutual of Omaha to deny the claim because now instead of being boxed into one occupation, it's basically any gainful occupation that's out there. Opens up the door, whatever your training, education, and experience qualifies you for. And typically they're going to say it's a sedentary job. They're going to say, if you can do a sedentary job, we think you can sit there and look at a computer all day and keyboard a little bit, we're going to deny your claim. So that's why most of these denials of approved cases are the 24-month mark during this change in definition of disability. Also, typically under these policies, there's also a mental health limitation at the 24-month mark. So if your case is, if you have a physical claim and depression, anxiety, PTSD, whatever it is, bipolar, they're going to try to deny you and make it only mental health claim because they can deny mental health claims at 24 months. So it's very important to build your claim prior to any 24-month period coming up because they're going to do their best to deny you at that point.
All right, so in a quick summary of the denials, we're talking about they're using their in-house doctors or outside doctors or doing file reviews. They're trying to tie it in often with some kind of video surveillance or social media surveillance, meaning they went out and got a claimant's Facebook, Instagram, Reels, whatever they're doing, and saying to the doctor, hey, look at this activity. Is this consistent with what's being reported in the claimant's medical records? Doctor will often say, no, it looks to be inconsistent. If they can do that, then they can do whatever, these are the restrictions and limitations, regardless of what the definition of disability is. And then Alex, you're saying this change of definition going from ONOC to ENEOC, and of course there's limitations for mental nervous. So now, person's watching this video, they go, well, what can this law firm do for me? And the remedies, and it's governed by ERISA, and then you file an appeal. And what a lot of people don't realize, because we have had phone calls from people who go, I've been denied by Mutual of Omaha. They said, just go ahead and file an appeal. Just like that, just go ahead and file an appeal, like as if it's nothing. Why is it so important, Cesar, when doing this appeal to get it right the first time?
Yeah, I mean, you only have so many bites of the apple or opportunities. The appeal process is part of a process that's been mandated by federal legislation, okay? Congress has given you 180 days to dispute and challenge this adverse decision that's been handed down by Mutual of Omaha. You have to think about that. 180 days. People think that's a long time. That's a long time of submitting an appeal. Why can't I just tell them I can appeal? I spoke to the Mutual of Omaha representative. They said, hey, just send us a letter. Send us whatever additional notes or records you have. You have that last visit? Send that to us. We'll look at that and we'll consider your appeal.
Right. A lot of people think, and this is a misconception, I always love, like, you're on the phone with a bank about a credit card charge or some fee or something, and you go, or you don't like something at a store and you go, let me talk to the supervisor. And you think the supervisor is going to come over and be customer friendly and try to resolve the situation. But this is not just, you have an appeal, let me get to the supervisor.
Right. Right. And that's certainly what, what I believe Mutual of Omaha probably would prefer. It cuts down the administrative time and cost that they have to be involved with your case, and that's it. They'll knock it out right there. There's almost a 95% chance your appeal will be denied. They'll just uphold that same decision. Why would they do that? Because you haven't really given them anything new. While it may have been reviewed and considered by a person not involved with the original decision, you haven't submitted anything new.
Right.
Okay. So that appeal process is absolutely critical to ensure that you're submitting not only new and supplemental medical records and notes, but addressing the reasons that they've denied you, perhaps going out and obtaining other additional medical support and evidence by way of, independent testing, depending on your condition, could be neurocognitive, it could be physical. There's different types of examinations and consultants that you could be reaching out to that will, provide you with the evidence necessary that will give you a substantially better chance of getting that decision overturned. Or if it doesn't, because oftentimes you go out and you get all of this together and you submit it and you're thinking to yourself, there's absolutely no way that my appeal is going to be denied and that this decision is going to be upheld. And then suddenly you find that they've upheld the decision, but now you're going to have your day in court. And if you hadn't gone through this process with your appeal and exhausted that and done this comprehensively and methodically, then you're going to have almost zero chance at the federal court level. So you've just overwhelmingly built up the chances and odds that you're going to prevail at the federal court level by how you prepared that appeal.
Yeah, and Alex, we always we love if we handled the appeal. We'll certainly handle a case if we haven't done the appeal, because the only remaining remedy is a lawsuit, which we'll talk about in a minute, about what you do if you lose the appeal. But try to convey to someone who's looking at this going, why do I want to learn about this, but why do I need a lawyer? Talk about how you're thinking about the lawsuit and the way the judge is looking at it when you're compiling and drafting this appeal for someone.
Well, what we have to stress is that once the insurance company issues a final denial letter of your appeal, the claim file closes. And someone's going to say, what the heck's the claim file? Well, Congress, they give us 180 days to file an appeal, but they also task the insurance company with creating a claim file. So every single piece of evidence that we submit as attorneys on our client's claim, or our clients submit, or their doctors submit, or every piece of evidence that Mutual of Omaha commissioned or ordered on this case, any review or anything that they gathered has to be inside this claim file. They have to provide you the copy of this claim file when you do the appeal, so you know everything that's inside this claim file, you know where all the reviews are, you know how to find the reviews, poke holes in the reviews on the appeal. But once they ultimately issue a final denial, if they do deny your appeal, the claim file closes. So, and the claim file is it's the only evidence that's going to get in front of the judge during an ERISA lawsuit. There's no testimony. My client can't go on the stand and say, I'm disabled here and here's why I'm disabled. Their doctor can't get on the stand and testify, what they saw when they treated this person, what the objective testing shows, or any testing shows, whatever. None of that happens under the ERISA laws. So the claim file is so very important. So when you do your appeal, that's why it's so important to get all that evidence in there, because if you don't, then you have no chance of winning your lawsuit.
When I do these appeals as well, and I'm thinking about all the evidence, because you win it with the evidence, right? But there's also a manner in which I think of it as a painting. You got to paint this in the right way where you're not telling the disability company, Mutual of Omaha in this case, here's everything you did wrong and here's what you need to do. Because they may follow your lead and then go out to another doctor or conduct another test and not get the result that favors the claimant being disabled, and then turns around and denies the case Then we try to go argue in court. And what are we going to say that they did wrong when Mutual of Omaha went ahead and did everything that we asked them to do? We're kind of stuck in a situation. So you have to understand the case law. And how could a claimant who's never been involved in a lawsuit, never done an appeal before, know what they should and shouldn't include when drafting this appeal? Because they have no idea. We've all read thousands and thousands of these ERISA disability cases. They're just in our mind. It's like a pinball machine in our mind about, oh, if I do this, then this judge is going to say this, and if I do this, this court's going to say this. And no, this is where I have to go. It's almost like landmines in a field. Like we have to walk here, here, and here. And if you go there, you're done. You blew it up. So a claimant can't do this on their own. They have the right to, but they're going to potentially go off track, fall off the cliff, get themselves in trouble. And that's the art of what we do when writing this appeal. And what you both stressed importantly was, if they did their own appeal and then they call us, we'll help them. But I can't get any more evidence in for you. If you got hit by a bus the day after the decision, I can't tell the court that now you just had back surgery because the bus rammed you or you have brain damage or whatever. Doesn't matter. Mutual of Omaha never needs to consider it, and the court never needs to consider it. But I want to take you, Alex, to now, this appeal that someone calls or an appeal has been lost, and the only remedy now is a lawsuit. And it's not the lawsuit that everyone thinks on TV where we all see, all right, now the claimant's coming in, I'm going to tell this judge and I'm going to tell this jury, this is what they did to me, this is how I feel, this is why I can't do my job or any job, and this company should pay me. It's not going to happen, at least not in their voice. It's going to happen through our voice. There's not going to be a testimony of the doctors. There's not going to be a testimony of any other witnesses. There's not going to be a husband, a wife, a child, a coworker, anyone coming in. Again, why everything has to be in the record. But what is going to happen in this lawsuit? How is it going to go down?
So you think there's going to be a jury of your peers sitting there saying, look at this normal person with a normal job making normal money against this billion-dollar company? No, there's no jury. All it is a federal judge, and the federal judge, depending who they are, they follow the law to the T. And the law is the ERISA laws are not really great laws for the claimants. They really do protect the insurance company. So you really need to have your ducks in a row when you file this lawsuit. So what's going to happen? You're going to file the lawsuit. Typically, the insurance company has 30 days to file an answer, and the answer is just basically denying all of our allegations and lawsuits. They're
standard.
Very standard. After that, the judge is going to issue a scheduling order. He's going to give all the deadlines for the case. There's going to be a mediation. Courts require mediation nowadays, which is where the parties get together to see if they can come to a settlement, because the courts love settlements. If there's no settlements, the entire judicial system would probably collapse because there's so many lawsuits out there. If the case doesn't settle at court or at mediation, then each side is going to file their motions for summary judgment. Like we said earlier, there's no testimony. It's a trial on the papers. The judge gets the claim file. The judge gets the written arguments and the motions for summary judgment by the attorneys, by each side, and each side has a chance to respond and reply. And ultimately, the judge will render a decision whether A, he or she thinks the person is disabled under the terms of the policy, and essentially B, whether the decision by Mutual of Omaha in denying this case was arbitrary and capricious, whether they had a reasonable basis to deny the claim. It's a high standard. It's one of the highest standards there are. So these cases are difficult to win, but everything is all in preparation. We keep on stressing it. Preparation in the appeal and preparation even when you're filing your motions for summary judgment. Prior even to mediation, there could be some settlement talks, because a lot of cases do end up settling. I'm never going to push my client to settle. I'm going to do whatever's in the best interest. I'll give my client as much information as I possibly can so they can make the right decision. Sometimes I always use the example that I tell my client, I'm the navigator, they're the pilot. I can tell them there's a storm ahead, we should make a right turn and land over here. And they go, no, we're going straight through that storm. So be it. But I'm going to give them the best information so they can make the best educated decision they could possibly make for their case. Sometimes a settlement is that best decision. Or I might say, listen, we have a 10% chance of winning here. This is the highest number we got at him. We got this number at him. This is your best. You should take this money and run. Sometimes I say, this money is crap. Let's go forward, let the judge decide.
Well, I think you gave a great summary there of what they should expect in this process, because it is completely unusual. And I tell people it's the wild, wild west when you get in there, because there's cases that say one thing and cases that say the other on the same exact situation. And that kind of works to the advantage of a claimant, because if the insurance company says, no, we're winning this case, we have the discretionary provision clause, arbitrary and capricious on our side, you can't win. And then we go, but look at this case. Well, then they got to go, you know what if the judge finds on that particular case, which is supporting the position of this claimant, we could lose. And so, Caesar, Alex touched on the word settlement, but I want to finish this off because people want to know, where is this going? Is the only remedy to have the judge make a decision, Or can I walk out of here with money in my pocket?
Yeah, certainly. I mean, there's the obvious conclusion, which is you win or you lose. If you win, you'll recover whatever back benefits. And this is what I mean by win is you've taken your case before the judge. The judge has, reviewed the legal briefs, the law, and he's rendering a decision that you're entitled to these benefits, and you're being paid from when they owe you up to maybe the time of judgment. If the judge has reached another conclusion, whatever that is. If they say you don't win, then you don't win. If they find that Sun Life's decision was reasonable, there was not an abuse of discretion, it was not arbitrary and capricious, then you will not ultimately recover anything in that action. So the other possibility is that there's a settlement or a compromise. Why do courts, like Alex was saying, that many courts mandate mediation? Because it takes the decision out of the court's hands. The court's decision is ultimately going to leave somebody very, very unhappy, okay? And it's going to take a lot of time to ultimately reach that decision. It could take months and years before the court decides that. So the compromise, the settlement, potential mediation, you're going to have certainty in what you receive. There's also the question of timing, because often it occurs much sooner than when the court would potentially render a decision. So those are the potential outcomes here. I mean, a settlement can certainly be success. I mean, it shouldn't be looked at as, I settled, so it wasn't a success.
Yeah, what's important for the person who's saying, they're kind of sitting there going, okay, great, what's the settlement going to be? And that's something that they should call us about, that we should discuss, because there's so many possible variables that I couldn't even tell someone to say it's going to be 5 cents on the dollar, or it's going to be 85 cents on the dollar, or I think you should go all the way and get put back on claim and get your attorney's fees paid for and made whole. But everyone's facts and circumstances are completely different. But what I do know is that if we accept the case, we're going to get an offer. I mean, we can't guarantee it, but we've never taken a case where we didn't get an offer based upon our experience and what we know about these cases. And there may be cases where, it's not the greatest case in the world, but if you're reasonable in what your expectations are, we may be able to get money for you on the claim, and in a reasonable time frame as well. When I mean a reasonable time frame, maybe just a couple months, just from after filing a lawsuit, because we have litigated so much against Mutual of Omaha and so many other disability companies that we've earned a reputation of the disability company knowing this company, this law firm, knows how to take this case the distance. They know how to advocate in the best way possible. Even if this case has one little tiny iota of a chance, they're going to find it and they're going to present it in the best manner possible, and we could lose. So instead, let's compromise. But the client also has to understand, we don't take cases just because the client's pissed off and feels that they did something wrong to them. Because as much as the company may have not come to a decision that makes the client happy, they may have complied with the law. And it may be a case that we just say, look, we can't win this case. I mean, in 9 out of 10 times, we're not going to win it. But it's still going to be money for you. And we're not going to mislead or misrepresent or say to someone just to sign up a client, hey, don't worry, we're going to win this thing. And then at the end of the day, you get a couple pennies. And what does that do? When we're not in that type of business to do just a volume practice.
And I realized that I think I said Sun Life earlier, because Sun Life and these companies are on my mind all the time. But Mutual of Omaha, but really, ultimately, it follows very much the same process once you get to that stage of litigation, right? You've got these potential points in your case, in your claim, where there's going to be some sort of determination or judgment or resolution that occurs. So.
And you guys both know Mutual of Omaha has a couple national lawyers who break up the country into a couple districts, and we've done so many cases with them that basically, whether it's before a lawsuit or after file a lawsuit, pick up the phone, call them and be like, this is a business-to-business relationship. Here's what we got. Do you want to review it and get it done? Or do you want to litigate and battle for the next year and a half? Pay your lawyers $100,000, pay us down the road, or let's sit at the table, because we want to get it done. The client is sitting there without money. We want to get it done as quick as possible. We understand that. So if you're someone out there who has a Mutual of Omaha, United of Omaha, whatever names they use. Give us a call, whether it's Caesar, Alex, any of our lawyers. No matter where you live in the country, we're available to assist you. And we look forward to the opportunity to provide you with a free consultation.